Hello and welcome to In Focus. I am G. Sampath. The government passed the Waqf Amendment Act 2025 sometime back, and it has caused a flurry of petitions, about 100 petitions challenging this act in the Supreme Court. Now, these petitions now will come up for hearing on May 15th. It will be heard by a bench headed by the Chief Justice Designate, Justice B.R. Gavai. And earlier, a three-judge bench led by outgoing Chief Justice Sanjiv Khanna had refused to put an interim stay on the amendments. But it did manage to extract two concessions or assurances rather from the Union government. One assurance was that there will be no denotification of any Waqf properties, including Waqf-by-user, in the interim period, or at least until the next day of hearing. And secondly, the government has also given an assurance that there will be no new appointments made to the Central Waqf Council or the State Waqf Boards under the amended sections 9 and 14 of this legislation. So, what is the exact status of the existing Waqf properties in this interim period, and what are the key issues raised by these various dozens and scores of petitions? Now, joining us today to discuss these questions is Supreme Court Advocate Shahrukh Alam. Shahrukh, thank you for joining us. Welcome to the pod.
Thank you for having me, Sampath.
Great. So to start with, I was wondering if you can tell us what is the reasoning behind the Supreme Court bench not giving an interim stay on the amendments, since there has been a great deal of controversy around them, and so many, almost 100, if not more, petitions were filed. So until the matter is heard, there was a demand that there should be a stay, but the Supreme Court has not gone down that road. So what was the reasoning, legally speaking?
Well, the Supreme Court has not given a formal stay, but the Supreme Court has given directions for status quo to be maintained. Now, what happens is when petitioners go to court and they make out a case, the first thing that the Supreme Court does, if it thinks that it's worthy of being heard, is to issue notice to the other side. And it directs the other side to file a formal response, which is called the counter. And then you file a rejoinder to that formal response. So the whole thing takes a while. They're given 4 weeks normally to file a counter, then you get another 4 weeks. It takes a while. But if you have an urgent case, if your case is that I can't wait so long, then what you say to the Supreme Court is, you hear me on my preliminary facts, and I will try and show you that the matter is so urgent, and on balance, what will happen if you don't give me an order immediately is that I lose out. It might become infructuous in 3 months when the matter comes back. So sometimes on those preliminary facts, the court gives a formal order, it's a judicial order of stay, nothing's to change, which is what was happening in this case as well. The petitioners made their preliminary case. The petitioners were arguing that on balance, this needs to be stayed for the moment. But the state said that they're not ready with their arguments on the first date. They said that they need to file more documents to make their preliminary case. But because of the urgency, because of the scale of the problem, the court said that we will either have to give a judicial order or you give an undertaking that there will be a freeze, which is what the state then did, because the state needed that time. So technically, there's no difference. On ground, there's no difference. There is a status quo. Conceptually, the difference is that it's not a judicially adjudicated order. It is an undertaking by the state saying because we need more time, we are agreeing to a status quo. Nothing will change on the ground. So there's basically a freeze, which says that the nature of any Waqf property across India cannot be changed in the interim. And two, that there will not be any reconstitution of any Waqf board or the Waqf Council in the interim. That works both ways. I mean, in the interim, it's very good, because if the matter is actually taken up quickly, then we'll be able to make our case. But if it's prolonged, the situation on the ground is that a lot of Waqf tribunals and Waqf boards have run their course, and there's been no re-election. So there are no Waqf boards operating or functioning in several places, including in Delhi. So in Delhi, for the last 2.5 years, there is no Waqf board. There is a senior bureaucrat who's been appointed by the LG as administrator, who's overseeing everything. So if there's no reconstitution, there's an adverse freeze as well. So that's how it works.
So in Delhi, there is no Waqf board operating. It's an administrator who's
For the last 2.5 years.
and he's been taking decisions about Waqf properties.
In fact, the infamous demolition of the Akhonji Mosque at Mehrauli happened under his watch. So it's not as if appointing a senior non-Muslim bureaucrat as administrator has streamlined things or has made things easy or has made things more transparent. In the Mehrauli case, for instance, that demolition of that particular mosque, which now they're saying was accidental, was one such concession or one such overlooking. But the fact remains that there is no Waqf board in Delhi, and I suspect there's no Waqf board in other places. They will run their term. So by default, again, a senior administrator will take over those powers.
Okay, so even with the current status quo being maintained, it's not necessarily as if it's going to benefit or protect the interests of.
In the short term, it does.
Okay.
But if it's prolonged, if it goes on for 6 months or a year, which chances are it will, because just looking at the scale of the case, right? There were more than 100 petitions. Now they've been scaled down to 5. But the way the courts work, with the filing of all the counters and other documents and then the rejoinders, it is going to take time. So if it's prolonged for 6 months or 8 months or a year, then the Waqf boards would end their term by default, and you'd still have a bureaucrat then.
So in effect, if the case sort of gets prolonged for a long time, and existing Waqf boards run their course and become whatever non-functional or whatever, then having an administrator run the show, so to speak, would be as good as a reconstituted Waqf board.
With a single administrator.
With a single administrator. That's worse than having a reconstituted
it's
Waqf board.
More concentration of power.
More concentration of power, right? So this assurance given by the government about keeping the status quo, is this only till the next date when the Supreme Court hears it, or is it till the final judgment is made?
On the first day, that was the understanding. In fact, the state said that we need more time because we need to show you documents to substantiate our case. And we need about a week, 10 days to show you those documents. So the undertaking was for the period until they come back and respond to the preliminary case that the petitioners had made, that there should be an interim stay. So the understanding was that. On the second day, they did come back with a counter, with documents. And the other thing that is sort of unusual and unique in a way in this case is that the bench is demanding, directing that we give in written things, petitions, counters, documents. They're actually reading it. So they're relying a lot more on the written word, so as to not spend so much time in court debating and arguing. So they come to court having read everything. On the last occasion, the Chief Justice of India said that we've gone through all the counters filed. But we feel that we don't have the time now to even listen to the preliminary arguments, because that will also take a lot of time. And the Chief Justice is retiring shortly. In fact, he's retiring tomorrow. He felt that he did not have the time to listen and to adjudicate. So he's now handed over the matter to the Chief Justice designate. It's for him to now do what he will in terms of the timelines, etc. In the interim, the undertaking does continue in a way. There's no formal order to that effect, but it's only appropriate that the undertaking continues for another week or so.
So why did you find it unusual, this sort of requirement to file everything in writing?
Because we're very argument heavy. That's been the practice, that's been the tradition. Benches often don't spend enough time, or lawyers actually don't spend enough time writing out their arguments succinctly, precisely, in the form of written submissions, which can actually be relied on as a substitute for, hours of arguments.
So it's a good thing then?
I think it's a good thing. If it's done properly, it can be a very good thing.
Right. So coming to the more substantive aspect of this entire controversy, Shahrukh, I mean, there is a concern. I mean, these Waqf amendments did have a basis in certain fears and apprehensions, which it is sought to sort of allay. One is, of course, any property can be declared as a Waqf property, and then it will go to the tribunal, which is composed of members from a particular community, and they will endorse it, and you can lose your property to the Waqf board. So this is something which has been there, which is also leading to this whole picture of non-Muslims being made members of these Waqf boards at the state level and so on and so forth. So aren't these concerns valid in a way? And even with the Waqf tribunal also, there is no further appeal. Once the tribunal decides, that's it, matter is closed. So these are some of the apprehensions which many in various communities do feel. So are these valid, or are they sort of overblown or misconceived in any way?
The short answer is that they're completely misconceived. But I'll also step back a bit and I marvel at the current times in terms of how the political narrative is able to hold and propagate two completely contradictory views at the same time. So, and it's surprising because our government actually talks a lot about decolonization of the mind, but it seems to have acquired the white man's burden. It treats its Muslim citizens as the savage people, half devil, half child, both naive and villainous at the same time. So that is the narrative, that there is a Waqf board which is so inefficient that it's frittering away valuable community property, and therefore the government needs to step in to make things more efficient. That's one part. At the same time, the Waqf board is also sort of always eyeing land and is also involved in land grabbing and adding to the already significant land holdings of the community. And both these narratives are being propagated at the same time. The inefficiency of the board and the almost predatory nature of the board. Then leading from there, the government steps in and makes two claims again. It says that we will ensure that there's no inefficiency. And to deal with the inefficiency, we'll bring in non-Muslim members. That suggestion itself, that bringing in non-Muslim members will somehow do away with the problems in the board and will make things more efficient, is problematic. It's discriminatory. It's not substantiated. Where is it coming from? And the second one, of course, is that it's predatory. The board is predatory, and we'll take care of that. That's one part of the problem. The second thing, which is where a lot of the concern is coming from, is that people generally believe two things. One, that Muslims actually have no business holding so much land, prime land across India. The fact that they do is a cause of concern and fear and derision. You'll find people laughing, saying the Oberoi is supposed to be Waqf property. Ha ha ha. Or the golf course is supposed to be Waqf property. How can that be? Ha ha ha. But the fact is that Delhi has a very specific history. The village of Nizamuddin has a very specific history. You can acquire that land, but there's no need for fear or for concern or for derision at the thought that Muslims did in fact have prime land. That's one. Two is the fact that this needs to be corrected. It's not right that they had so much land. This needs correction. And third is that the Waqf board and the Waqf tribunal are some shadowy Muslim concerns. And they were enabled by the old appeasement regime and the old appeasement laws to just put their finger on any property and declare that as Waqf property and then take it over. And like you said, that then this would be endorsed by the tribunal.
This is a general perception.
This is the general perception, yeah. And there's no appeal from the tribunal. But two things, this is not factually correct. The process is, that both the State Waqf Boards and the Council, the Central Waqf Council and the tribunal, they're all statutory bodies, which means that they are the state under Article 12 of the Constitution. So all the checks and balances that apply to any state body will apply to them. They are amenable to the Article 14 guarantee. They can't be arbitrary. They can't be unfair. They're subject to all those guarantees. Second of all, who is the Waqf board? the Waqf Board had elected Muslim representatives, which included members of parliament, members of the Legislative Assembly, lawyers, scholars, etc. It also had bureaucrats. It has state officers. It has gazetted officers who happen to be Muslim. Now, in suggesting that the State Waqf Board is a Muslim body and these bureaucrats are actually just acting as Muslims, not as officers of the state, is a very problematic stand. Similarly, the tribunal has a district judge as its chairperson, who's any district judge who's designated to the tribunal on rotation. He may sit in another sessions court tomorrow. He may sit in a district court tomorrow. In that moment, his posting is in the Waqf tribunal, but he's a district judge, or she's a district judge. There's also an officer from the revenue department who sits in the tribunal. And then there's a scholar of Muslim law who sits in the tribunal. These are state functionaries. I mean, he's a judicial officer. To again dismiss such an officer as being Muslim and the Waqf tribunal as being a Muslim tribunal is very problematic. This is the constitution of the tribunal and the board. But now, what is the procedure? The old act laid down 4 levels of scrutiny before the Waqf board had the power to declare any property as Waqf. So the first was the gazetted officer, who's the survey commissioner, would make a comprehensive list of all properties that claimed to be Waqf properties. That list was then sent to the revenue department of the state government for verification and scrutiny. Once that was done, it was again sent back to the Waqf board for further verification and review, and then back again to the state government for a formal notification. So there are 4 levels of survey, verification, scrutiny, review, and then a notification. And both the survey list and the notification were amenable to a challenge, to a judicial challenge. You can challenge them in the tribunal. So it's not as if they can unilaterally just put their grubby finger on any property and say this is Waqf property, right? There's another section in the old act which everyone got very, very sort of hyper about. That was section 40, which says that the Waqf board can unilaterally or suo motu declare a property as Waqf. But even that, the Supreme Court has said, doesn't mean that they can just walk up to a property and say that this is ours now. What has to be understood in that section is that there must have been a survey, and they must hear both parties before they do this, and they must give a reasoned order explaining how this property is theirs, and the reasoned order is then amenable to a challenge. It's subject to a challenge in a writ court. So there were always all these guarantees. They can't appropriate any property at will. And last of all, the fear that the tribunal, the orders of the tribunal cannot be appealed. That's true, but they were always subject to the writ jurisdiction. If they're arbitrary, if they're unfair, allegedly unfair or allegedly arbitrary, you can challenge them and go straight to the High Court and then to the Supreme Court, which is what was being done all this while.
Right. So, the writ, the Waqf tribunal is like any other land-related tribunals.
That's
in that
the
sense.
other point, that when people say that the Waqf board can claim any property as Waqf, they forget that the Waqf board is a state body. It's a state autonomous body, and all other bodies of the state which deal in land, the land acquisition authority, the forest authorities, even something as simple as the Public Premises Evacuation Act. These are all authorities, and all these acts give state the first claim to land. The state can declare that I am acquiring your land tomorrow, and you have to abide by that unless there's a decree, unless there's a judgment in your favor. So that is the arrangement vis-a-vis the state and land in general. This is not something that is unique to the scheme of the Waqf Act. The state makes the first claim, you have to go to court, and you have to await a judgment, which does make the private owner very vulnerable. But then we have to think about the comprehensive scheme and challenge the comprehensive scheme, not pick out the Waqf Act alone.
Right. I mean, I appreciate you sort of for the clearing the air with regard to this perception that the Waqf board can usurp basically any property through these opaque processes and so on. But that's a
May I
perception.
add one other fear to this? A lot of the apprehension has come from what people say are vulnerable private owners, small landholders.
Exactly. Yeah.
And they fear, they say that, the Waqf board can turn around and claim my land is theirs. And there are problems because sometimes these people are so marginalized and so poor that they're not in that loop when the survey list comes out, when the verification list comes out, even when the notification comes out. The poorest, most marginalized people are not even in the loop. They're not able to know what is going on and challenge it in time. But the amendment doesn't take care of that at all. What the amendment does is it takes power from a state autonomous body, gives it to a designated officer / district collector, one officer who happens to usually work very closely with the political leadership, such as the district collector. And the amendment says that now the district collector can declare a disputed Waqf property, where there's a dispute between the state and the Waqf board, as state property. And it shall stay that way unless there's a judgment setting that aside. So he has the power to declare something which was earlier Waqf as now state property, and then the Waqf board will have to await that judgment, a judgment in their favor. But this only applies to public land. This does not change the arrangement between the private owner and the Waqf board. The district collector can't help a farmer and say, no, your property is disputed, I'm declaring it as yours.
He can't do that.
He can't do that. So the private owners will still have to await their judgment, their day in court, which will take 10 years, 12 years, 15 years, whatever. That does not change. This is only vis-a-vis government land and Waqf land.
Okay.
Right? So it also has a very political angle to it, because all the disputed land, all the land that the district collector now has the power to declare as non-Waqf and government, are land that is, or are monuments or buildings that are in the political / public eye. Right? In a way, it circumvents the Places of Worship Act.
Right.
It has no effect on private ownership.
Okay. So, when speaking of land, the kinds of land which are in the public eye, which come into dispute and so on, one of the claims made by some opposition politicians, especially from the south, is that this amendment. I'm talking about opposition politicians. They have claimed that this amendment is aimed at enabling the state. I'm just quoting their point of view here. Enabling the state to usurp hundreds of Waqf-by-user properties in prime locations, which were made by Muslims who left India during the time of partition. This is a very strong claim. Is there any merit to this kind of point of view as well?
I should think so. One, because the district collector or the designated officer now has that power. Wherever there's a dispute, until that dispute is adjudicated, which we know will take a long time, he can make a unilateral declaration and say that I'm taking over. This is state land. He can also change the nature of the land. He can alienate that land in the interim. So this is a huge inversion of power. Now, what kinds of lands are usually in dispute between the Waqf board and the government? Usually prime land, usually land that's not formally registered as Waqf property, or there's no challenge to that registration, which is then Waqf-by-user. And Waqf-by-user are religious or semi-religious, quasi-religious, cultural spaces, monuments, dargahs, mosques, graveyards, where there's no formal registration. Because it's been practiced as a particular space, it carries on. So then the DC will now have the power to take them over. But what I would add is that it doesn't even apply to properties that were left behind by people who later migrated to Pakistan. This can also apply to ancient medieval monuments. The dispute in Mehrauli, for instance, was around a medieval mosque and a medieval tomb. And then the forest department was saying that this is actually forest land and we are acquiring it. Now, in that dispute, legally, the DC can declare that this is government forest land, and I'll change the nature of the land.
Okay. So what happens to all the Waqf structures? You gave a couple of examples which are not registered as of today. What happens to them?
The Act suggests
The amendment Act.
the amended Act suggests that they will now no longer be recognized as Waqf-by-user if they're not registered. If they are registered as Waqf-by-user, they will be so recognized. But then again, there can be no new registrations of Waqf-by-user unless there's a formal declaration that this is Waqf property and this is the arrangement I'm making. It can't be left to vague user practices now.
So as of now, like what percentage of Waqf-by-user properties are registered? Are like most of them unregistered? Or like?
I think I don't have percentages, but my guess is that they're mostly unregistered. Right. Because the whole concept is that usage makes it Waqf, and you can't change that now.
So another sort of murky area is...
Sorry. The second part of it, which talks about evacuee property or enemy property in a way, the unamended Act talked about evacuee property and said that if there are any Waqfs, Waqf-by-user or Waqfs otherwise, they will still be controlled or governed by the Waqf Board. That has also now been repealed. So now if there is evacuee property, its status is again made unclear. It can very well be taken over by the government.
Right. So another controversial aspect of this entire bill is the introduction of non-Muslims into Waqf boards. So I was just wondering, how do you expect that to sort of help or not help the way the processes function? Will it perhaps open the door to demands, counter demands, maybe for the introduction of non-Hindus to equivalent management boards of other religious bodies? Logically that seems to.
Personally, for me, the inclusion of non-Muslims, is not a problem. It makes it diverse, it makes it plural. For me, the implication is a bigger problem, which I talked about in the beginning. The implication is that you're naive, you're silly, you can't manage your own affairs, and so therefore we'll bring better people. That's the first implication. The second is that you're dishonest, you're predatory, and therefore we need to bring non-Hindus to keep an eye on you. Both these implications are very problematic. And the third very problematic implication is that bureaucrats or judges who are Muslims are not trustworthy. Even though they are officers, they're not trustworthy, so we need other officers. On those grounds, for me, this is extremely problematic. It's also reminiscent of Lord Dalhousie and the doctrine of lapse, right, where he said that if there's misgovernance, if there's misrule, we'll just take over. But we know that was only about annexation and control. It had nothing to do with better governance. It had nothing to do with transparency. But that aside, the main crux of the argument on the petitioner's side seems to be this, though, that this is violative of Article 25, 26. So why would you bring... And minorities have the right to govern and administer their own institutions. So why would you bring in non-Muslims? Whereas other communities have not been subjected to a similar inclusion. And I think in response to this argument, the bench did ask the state on the very first day. They said, would you be open to having Muslims on temple boards, etc.? To which the state had no answer.
The state had no answer, as in they didn't give a response?
They didn't give a response.
Okay. So, you spoke about a couple of issues, which were there in the petitions. So, before I have one last question for you. Before I come to that, I wanted to just check with you there. What are the other main issues? There are like more than 100 petitions, and I think this court has taken 5. What are the other issues apart from the ones we have discussed so far? Are there any other issues that you think?
Well, the thing with, you can only have so many issues, and petitions are always very repetitive. Mm-hmm. So I also want to say that this was again a first in a long time when the court said that it's just repetitive and we'll just take the first 5 because we don't have the time and the resources to listen to the same thing over and over again. And I thought this was remarkable in terms of court management, although people may feel that their right to an audience before the Constitutional Court has been taken away. I think it's very useful because as a pattern now, especially in cases that have a political aspect to them, you talk about hate speech, and all these other cases, the pattern has been to make a hearing completely untenable by flooding the court with petitions. So you file one on hate speech, the other side comes and files another 5, then you file another 3, then there are another 10, countering each other. So you're talking about a particular hate speech by, say, the Hindu Mahasabha. Then there'll be another one saying, but what about Periyar? Or what about Asaduddin Owaisi? And it happens to an extent where hearings become untenable. You can't manage some 200 petitions. So I think this was remarkable because the understanding also is that beyond a point, everything is a repetition. It's just another person saying them. So the court has said that we'll only hear 5, and that too you'll have to streamline. You can't be repetitive in your arguments. But the arguments are broadly that this is violative of 14 because it's arbitrary, it's violative of 25, 26, and 30 as well, because a lot of the financing of madrasas comes through Waqf properties. So they're saying that if you disturb that, a lot of the educational institutions will also get disrupted. So broadly it's that, and secularism and fraternity as well.
Right. So my last question to you, Shahrukh, assuming that the Supreme Court upholds these amendments in their current form, what would be the process followed for resolution of disputed Waqf properties? And in the big picture, how do you think it's going to have an impact?
So the balance of power will change in the sense that, at least in terms of government properties, not in terms of private properties, the DC will have first claim. And then the Waqf board or the Waqf institutions will have to go to the tribunal. The tribunal will decide one way or the other. And now there'll be a process of appeal from the tribunal.
So basically the balance of power will go to the political political side of the government, basically.
Yes. Okay. Because the Waqf board is also state. So it's not even the state. It's more government versus state autonomous institution.
Right.
And then you will have to wait in court all those years, and the property will vest with the government for it to do what it will in those interim years.
Right. That's all I have for you in this conversation. Shahrukh, thank you so much for coming over to the office here, and a pleasure talking to you.
It was a pleasure talking to you. Thank you.